I don't like to comment on every new DEI related lawsuit, but this one is a significant development. On Wednesday, the Department of Justice filed suit against Minnesota challenging the legality of the state's affirmative action program. Here's why I think it's a case to watch. In 2023, the Supreme Court effectively ended race-conscious admissions in higher education, finding that Harvard and UNC's admissions processes violated the Constitution's Equal Protection Clause and Title VI of the Civil Rights Act of 1964. However, the court did not say anything about two old Supreme Court precedents, Weber, 1979, and Johnson, 1987, which authorized some forms of workplace affirmative action under Title VII of the Civil Rights Act of 1964. In other words, after its 2023 decision, the Supreme Court left us with a weird legal landscape in which affirmative action in higher education was unlawful, but affirmative action in the workplace was technically lawful under Weber and Johnson. With this new Minnesota lawsuit, that could change. The Department of Justice inveighs against Weber and Johnson in its complaint, arguing that they were wrongly decided and violate Title VII. The DOJ has also requested expedited review by a three-judge district court with direct appeal to the Supreme Court. This suggests to me that the DOJ is hoping it can rocket this case to the Supreme Court and ask the justices to overrule Weber and Johnson, officially ending affirmative action under Title VII. Does this mean the sky is falling? No, for a few reasons. For starters, there's no guarantee the case will get to the Supreme Court. We're still at a very early stage of the litigation. The vast majority of employers these days aren't engaging in formal Weber and Johnson style affirmative action anyway. Most importantly, we at Inclusion Score have based our legal guidance over the past few years on the assumption that Weber and Johnson are essentially dead letter rulings, and that the current Supreme Court will extend its reasoning in the 2023 affirmative action case to other domains like employment, contracting, and grant making. I referenced the New York University Meltzer Center's 3Ps model, their encouragement to move from lifting to leveling and from cohorts to content, and everything else we've written on this subject. All of it is premised on the assumption that a case like the Minnesota lawsuit would inevitably arise. Nonetheless, this case is worth watching closely. If the Department of Justice gets its way, it could be the first time the Supreme Court explicitly opines on the legality of workplace DEI and DEI adjacent practices since its 2023 affirmative action rule.